Hi, my name is Megan Garten, and I'm one of the reference librarians, and I'm excited to be here today to talk with you about legal research. There is many steps in the process of legal research, and one of the first things I can tell you is legal research is hard. It's difficult. It's just a skill like any other that you're going to learn as you're going through law school, just like you're learning to brief cases, just like you're learning to outline. Legal research is just another skill. So today I want to preview all of the different component parts that will make up being a good legal researcher. And legal research is so important, especially for your summer jobs and obviously in your legal career, because that's one of the first things you'll be doing, especially as a summer associate, is research projects. So the more you can set yourself apart as a good legal researcher, the better, obviously, for you. So let's get started with what I call don't fall in the bear trap. What bear trap am I talking about? That one that says, I am going to start my legal research. I don't need to make a plan like that reference librarian told me to. I'm just going to start researching some cases on Lexis and Westlaw, put in some keywords, see what I find, and start reading. That's a very common instinct that students have, but it is really not the most efficient use of your time. And today I want to walk you through how I would recommend you go about the first time you receive a research assignment, the different steps that you would go through to basically create what we call a research plan, and also to start using a research journal. And we'll get more into what those two different things are as we go forward. But I know it will be difficult for some of you to think, but I really just want to start searching on Lexis and Westlaw. And again, as I said, that's very common. But I urge you to think of legal research on Lexis and Westlaw when you're reading cases, just like you would if you were reading a foreign language. And you don't know that language, so you have to stop every time and look up every word in a dictionary. And even if you took all that time to do that, you still might not understand what you're reading. And that's the bad part of just starting with reading cases on Lexis and Westlaw. You can read cases, but you don't necessarily understand what they mean. So after you make a research plan, the best thing that you can do is to start with secondary sources, not cases. And when I say secondary sources, and I'm going to say that many, many times today, but they're just that important, you have to find secondary materials, things that are written about the law that are trying to help you understand it. And those things are treatises, encyclopedias, law review articles. Secondary. What is considered primary are cases, the actual law. So primary sources are things like cases, statutes, regulations. But for your research, you're going to want to start in any number of secondary sources, and we'll get into more detail about that. And you want secondary sources because they will make you look smart. You will get a background and context and understanding of this area of law before you start reading cases, and then you'll be much better able to pick what cases you want to spend your time on and which ones are less relevant to you. So just as an example, what I call Dr. Seuss ease versus legal ease. So when I talk about, you can start reading cases, but just because you read it doesn't mean you actually understand it. And the same goes with these two sentences here. You can dissect that sentence. You're all very smart students. You know who the subject is and what happened. But what is beneficiarias under the plain language of ERISA? What is ERISA? These are the kind of questions you're going to come across anytime you just start reading cases. So the best thing you can do is start in a secondary source, and we're going to look at all the different types that are available to you and their pros and cons, and then get you started on making your research plan. And just as an aside, ERISA and QDROs that we're talking about here, it's actually the Employees Retirement Act, and QDROs are orders if you've been divorced of how your retirement fund will be distributed to a spouse that a court has ordered. Sorry about that. So let's just start and jump right in. Why in the world am I asking you to take time to make a research plan before you start, and not just jump into reading cases. And the best I can tell you is it will pay off in the long run. A research plan can mean many different things to different people. Mostly think of it as like a plan of attack. Where are you going to start your research, and how are you going to move forward? It does take time, extra time, to create a research plan and to do research journaling as you go along, but strategic thinking from the beginning and being more organized is always going to help you draft your assignments more quickly. So what does this research plan do that I keep talking about? The first thing is it will help you isolate what are the legally significant facts. Usually you'll get some kind of assignment from an attorney, and they'll give you some description or background of what's going on in the case and what they want you to look into. And there will often probably be many facts that may not be all that legally relevant. So you're trying to figure out which are the legally relevant facts. The other thing a research plan helps you do is right from the beginning, you're starting to think in an organized way. What I mean by that is sometimes there are many legal questions that will surround whether your client can do whatever it is you're being asked to research. So if they're involved in a battery and you're researching what the battery cases and statutes may be in your area, one of the first things you have to consider is, does that client even have standing to bring the suit that they're trying to bring? And standing just means, are they legally able to bring a cause of action in a court? And so you could see how if the standing of your client is a main issue, you're going to want to start your research by researching that very issue itself before you even jump into what are the elements of battery. Do my facts prove those or not? So the research plan is going to help you organize where you're going to start and where that will lead you in the future. And once you actually start researching, as I've mentioned, the best thing I can recommend is keep some kind of journal or record of what you searched, when you searched it, what you learned from those searches, and any potential keywords or helpful things that you find when you come across. And it doesn't have to be super formal like a spreadsheet, but it certainly can be a spreadsheet or just like a written Word document, or however you want to record what you're doing as you're going, because you will spend so much time doing it. You're going to want to make sure that you can remember, what have I searched, where have I searched it, what did I learn from it? And we'll talk a bit more about why that's so helpful in a bit. So research plans, you want them because they will help you organize your argument better and figure out what it is you even need to start researching. So the main components of the research plan has several different parts. So the first part is you just want to say, what are even the questions I'm trying to research? That's kind of part one. Part 2 and 3, you need to identify these magical secondary sources that I've talked about that are going to help you get that background and context. And also part of 2 and 3 is find keywords or terms of art, which are unique phrases or words that we use in the law that you wouldn't necessarily know from everyday common language. And your partner who gives you the assignment may not necessarily use them. So you have to figure out what the terms of art are as you're going. And then the last part of a research plan, it gets into refining. It's an ongoing process. So the more you learn and do research, the more that will inform what you've already understood. And you may find that, oh no, there's a whole separate element out there I hadn't even known about at the beginning. And then you refine, go back, make a research plan for that new thing. Where you're going to start, what resources may help you answer that question. So part 1 is very similar to what we talked about so far. Basically strategize and assess what you know. What do you know? As 1Ls, it's usually fairly limited, which is totally normal. So assume that you don't hardly know anything about that area of law is a very reasonable thing to do. So again, I remind you, don't get caught in that bear trap. You want to make some kind of plan to figure out where you're going to start. And one of those first things you're going to have is some kind of research problem that's given to you by an attorney or just, in the hallway as you're walking by, they'll say, why don't you research this thing for me? And the usual main questions are, who are these players? What jurisdiction are you in? What are the legally relevant facts? And what is it I'm really being asked to research? Because you always want to make sure you understand the scope of your assignment and what they want, and any relevant financial or time constraints obviously are going to be super important. So during this first phase, identify what don't I know and what do I know? What area of law is it? What do I know about that particular area? Do I already know any secondary sources that might be helpful to me? And again, I encourage you to have a written plan, but it can be as informal or as formal as you'd like it to be. And you're basically just saying, what have I tried? What did I learn? And any important things you found along the way. And that gets back to keeping notes, some kind of journal. The more detailed and organized, usually the better, because you don't want to start your research over every time you come back to it. The next day, you don't remember exactly what things you searched or what secondary sources you looked in or what keywords or terms of art you tried. It's just best to have some kind of written record to help yourself. So part 1, strategize and assess what you know. Part 2, I will emphasize again, use those secondary sources. Don't follow your instinct and just start looking up cases on Lexis or Westlaw. Think, there are these secondary sources, materials that help me understand the law, and I need to find some of those. That will be the most efficient use of my time. And a 2-for-1 bonus is that secondary sources also will cite you to the primary sources. Again, primary sources being the actual cases and statutes. So like in the footnotes at the bottom of the page, it will cite you to actual cases, but the secondary sources will have descriptive information in the body of it that's helping you understand what is this area of law? What are the elements that may be required to prove this cause of action? So you're trying to fill in any holes. First, you usually have to determine what jurisdiction are we in? Is it a federal court? Is it a state court? What state am I in? What circuit am I in? All those kind of preliminary matters. Is it a state kind of issue? Is it a federal? It can obviously both, depending on what kind of issue you're looking into. And you can think about, is this likely to be something where there is a statute in place? Is it going to be something where there's only case law available to me? It can just totally depend as you're going forward. And the second part of secondary sources is they're the best place to figure out what these terms of art are that I've been talking about, so that you can put in one keyword that's the term of art that's most relevant for your search and quickly, efficiently find what you need and not have to wade through tons of cases that are not as relevant. And again, it is a lot like learning a new language. You have to learn the vocab, which will be these terms of art, and secondary sources are the best place to start. And that gets to why just jumping into cases on Lexis and Westlaw isn't the best, because you don't even know what terms to search yet, or what are the best terms to search. Okay, so part 3. Finally, we're getting around to primary authority. You will cite to primary authority in your briefs and memos. You will rarely, if ever, cite to a secondary source. You will need to cite to primary sources like cases, statutes, regulations. So once you have used secondary sources to smarten yourself up so you understand this area of law, one of the best things you could do is then take those terms of art and go into Lexis and Westlaw and search and find the cases and statutes that are the primary law that relate to those terms of art or area that you're looking for. One common thing, there are Cali lessons that can help you. Sometimes it's not as easy as you might think to determine, is this a state issue? Is it a federal issue? Because the state can regulate something and the federal government can also regulate that same thing. And so you have to be clear of what court you're in and what particular issues you're looking for. Okay, so we finally have assessed, we've used secondary sources, we've actually found some cases. Part 4, reassess. Almost always, as you're going through this process, think of it as nonlinear. You're constantly learning new things, you're following different leads, and as you learn more, you'll be better able to revise your searches normally and think of other places that you could look in secondary sources that could be helpful. So it's never a straight line. I look in secondary, I find some keywords, I look at some cases, I'm done. Very rarely, especially as a new researcher, you're going to look in secondary sources, figure out what is this area of law, what are some of the key terms, look in cases, and then realize, oh, there's this whole other issue that's involved that I hadn't thought about yet. Go back, start that same process over, and just keep moving forward as you're refining exactly what it is you're researching and what new sub-issues you've come across that you didn't even know about in the beginning. All right, step 5. When we talk about cases, there is a big difference between whether the case that you find will be persuasive precedent, and that's what we're talking about in part 5. In part 3, where we're saying find the primary authority, it's always best to find the cases or statutes from your particular jurisdiction. Like if you're in Louisiana, you want to look for Louisiana cases and statutes. But sometimes you will find that Louisiana may never have had a case like you're trying to research before. There's literally just nothing in Louisiana that is on topic for you. That's when you would then consider what is called persuasive precedent. And that just means like the court doesn't have to follow it. It can, and you and your argument will help them decide, yes, I will follow this persuasive precedent that's from some other jurisdiction. They don't have to, but they can. And again, that's contrasted with mandatory precedent, which is anything that's actually from your home jurisdiction and is binding a higher court, binds a lower court. So once you know what your jurisdiction is, then you can see, am I finding primary mandatory precedent? If you've gone through that and you're finding some gaps and holes that aren't covered in your home jurisdiction, which is normal, you would then start branching out and looking at other jurisdictions that would be, again, persuasive to the court, but not binding on them to follow. So our little friend here, the Second Circuit doesn't have to care what the New York State Court says about anything, but if it's a good argument and you find it very helpful, you can explain to the court why they should follow that same precedent that the other court had. And as I said, if there's never been a case like yours in your jurisdiction before, you literally will only be able to have persuasive precedent, meaning from outside your jurisdiction. And we delved into a little bit of this binding versus persuasive, mandatory versus persuasive. I've got a whole other separate guide I'd recommend you check out because it actually is a bit more complicated than it could seem. And I've tried to put this guide together to help you get into some of the minute issues, because it can make a difference if you're in a state court or you're in a federal court, what different court is binding on you. So just know, I encourage you to check into that once you start getting into really looking at some precedent and finding persuasive cases. Okay, so you finally found some cases. They may be mandatory from your jurisdiction. They may be persuasive from an outside jurisdiction, but you're feeling good about that. The next part of your research is going to be verify that that primary law, the cases, statutes, and regs are still what's called term of art, good law, hasn't been overruled by another case or a statute or found unconstitutional. And there are very strict malpractice considerations to not properly making sure that your cases you're citing to the court are good law. You're going to do this on Lexis or Westlaw, depending on which one you prefer to use. You'll see different colored symbols at the top of the page when you're looking at a case. And on Lexis, the red stop sign means warning, negative treatment. Something about this case has been potentially overturned or overruled or found unconstitutional. On the Westlaw, you'll see a similar red flag that is saying severe negative treatment. So what does that mean for your research? That means just because you see that a case has a red signal, that doesn't mean you just X that case out and say, oh, I can't use that case. It's red. It's not good law anymore. It gets more in depth. You have to see if that case has been overruled on the point of law you're actually researching. So it's possible for part of a statute to be ruled unconstitutional, but other parts of it to still stand and still be the actual law. The same with cases. So you have to get into that case and see, are they talking about what I'm trying to research as being overturned or not? On Lexis, it's called shepherdizing. That's just the word that attorneys use. On Westlaw, it's called key citing, but it's the exact same thing. You're just using those signals to determine where is this case. Some cases will be green, some will be yellow. There'll be a little indicator that you can mouse over and read. Depending on how long a time frame you're talking about, you can usually get it away with just checking once. But if you're doing a project that's taking a long amount of time, it's very possible that new cases can come out that would give you negative treatment, and you don't want to be caught in front of the court with something that is no longer good law and you've cited it to them. So just keep in mind the time frame of how long you've been looking for things. I highly recommend these two short videos on Lexis and Westlaw about how to do the key citing or shepherdizing. Okay, so we're finally to part 7, that part, when to stop, a very common research question. A good rule of thumb I always find most helpful is to say, are you seeing the same primary sources cited over and over again? If you're looking at a secondary source and you've already read every case that it mentions, you start to feel like you have a good assurance that you found everything in that area of law, every case that would be important. Have you updated and validated those sources? So have you done that shepherdizing or key citing? Did you go through all the steps of your plan? Is another great way to know, and why a research plan helps so much, because you can review, yes, I've checked this type of source, I've checked that type of source, I use these keywords, and I feel like I'm not seeing anything new. That's the best indicator that you can stop. And Callie does have a separate lesson I've linked right here that tells you when to walk away and when to keep researching. All right, so that's the overview, excuse me, of the 7 research plan components. I want to go into a bit more detail of almost all of them as we have time today. The first one, the most important really, is what are these secondary sources I keep talking about, and where will you go to find them? So I've broken it down into, again, explaining why secondary sources are so helpful. They help you fill in your knowledge gaps. They will tell you terms of art that you have no other way really of figuring out. The 2-for-1 bonus, they still cite to primary sources and footnotes, so you can start reading cases as soon as you have done your secondary source background research. There's lots of different types, so we'll get into a bit of that. I've broken out what I call the secondary source cheat sheet. If you are new to an area of law, these are the secondary sources I would recommend that you use. If you have some familiarity with that area of law, these are the resources I would highly recommend that you start with in secondary sources. And if you feel like you're an expert in this area of law, and someday it's very possible that you will feel like that, there are some other secondary sources that I'd recommend. But as 1Ls, as new researchers, I would always recommend you start with the new to this area type of sources. And so those are legal encyclopedias. It works just like an encyclopedia you used in school. It's just arranged by topic, and on Lexis and Westlaw both have legal encyclopedias. One of the most popular is called AmJur, which stands for American Jurisprudence. Corpus Juris Secundum, commonly called CJS, is another encyclopedia. And then each state may have its own specific state level encyclopedia. Another helpful place you can start is a study aid like a nutshell. And those are just really short, good outline overview of an area of law that's going to help you know, like, what are the main topics? What are these keywords that I need to be looking for? The other place you can start is called the American Law Reports. And I always call that legal research gold, because what you will get is a very detailed article basically on a very narrow topic of law. So if you find an ALR article that is right on topic for you, you've literally saved yourself hours of research, because it's going to give you secondary source type background information, describe the area of law, give you the lay of the land. It's going to have keywords and terms of art mentioned throughout, and it's going to have footnotes that will lead you to the primary actual cases as you get started in the reading case phase of your research. There's really no better place to start when you're new. I often would recommend start first in the legal encyclopedia, because it will give you the broadest overview of that area. And just keep in mind, as I said, American law reports are very detailed and very narrow on topic. So it is possible that you, if you don't start with a legal encyclopedia, won't even have very good keywords or terms of art to search in the ALR. So if you're in the ALR and you're just finding there's lots of stuff you don't quite understand yet, or there's too much, I would suggest going back to the legal encyclopedia, because it gives you the broadest overview and background on that area of law. And then move into the ALRs. If there's one on your subject, that's great. Next semester, when you're doing your open memo, we will get more into the some familiarity with type of area. And the biggest difference is in that some familiarity phase, you will start using what are called treatises, or just books written by experts on areas of law. And there's all different kinds of treatises. There's all different kinds of lengths. Some are of 1 volume, some are 30 volumes. So we'll get more into that. But at this time, focus mostly on your legal encyclopedias like AmJur and the American Law Reports. And we'll quickly look at this, just a pros and cons, basically. There's lots of different types of secondary sources, and they're listed on the side over here. I then give you their pros and cons, because everything has pluses and minuses, and then where to find it. So if you were trying to find a legal encyclopedia like AmJur on Lexis or Westlaw, you could just come here and click. We do have them in print, but I'm sure most of you would prefer to search them on Lexis or Westlaw. The same thing with secondary sources like law reviews, I'm sure you're much more familiar with. And I also have a link here to the ALR, which is available on Lexis and Westlaw. They both have that content. Sometimes they only have their own content that they publish, but other times like this, they both have paid for access to that content. So that would be my biggest overview, would be legal encyclopedias are broad and American law reports are very narrow. So depending on how much you do know, they're the best places to start your legal research. Okay, so we're talking about keywords, these terms of art. I don't have time today to go into the actual searching strategies for Lexis and Westlaw. And there's another guide I put together here when you're ready for that stage of your research. I highly recommend. So at this time, we're just going to talk generally. Why are these terms of art so vital? Why do you have to look at secondary sources just to find them? So for example, let's imagine that you are trying to figure out what jurisdiction a lower court retains when a case is on appeal to a higher court. And they ask you to research, can a lower court continue to make decisions regarding that case, like amend it while the case is still pending in the appellate court? So if you don't know much about that area of law and you're a new researcher, you can think of normal keyword terms would be like court, appeal, jurisdiction, but those again are very generic terms and very likely to appear in lots of different cases. And you have to try and narrow down specifically on what can a lower court do when it's the case is on appeal. So if you looked in a secondary source, like a legal encyclopedia or the ALR, you would find that the key terms of art for that kind of area of law are divestiture and functus officio. So rather than going on Lexis and Westlaw and searching court, appeals, jurisdiction, if you go on Lexis and Westlaw and put in divestiture or functus officio, you will so much more efficiently find just those cases that you're looking for, and that will save you so much time in the long run. How to find these terms of art I've been talking about in the secondary sources. One of the best ways is just to look in the index of that secondary source or the table of contents, which will be found at the front. And it will give you like the big headlines. What's this chapter about? What's that chapter about? And just looking through those and skimming them will be the best way to figure out what's this area of law all about? What issues may I need to further research to determine going forward? And what are the terms of art that they're going to be using? And always, you can ask a reference librarian to help you. It's not a violation of the honor code to speak with us about your research. So don't hesitate to ask us about it. I wanted to give you a few more examples because I just can't stress enough how important secondary sources are to help you find and learn about these terms of art. So if you're trying to find something about an CEO getting bailed out because the company is getting taken over and it's been tanking and he's maybe sued for, a Ponzi scheme of some kind, if you know that the term of art for that is golden parachute, and that's what you're searching on Lexis and Westlaw, you're going to be so much more efficient in your research than if you're just searching key terms like the CEO, left company, trouble, things like that. There's all different kinds of these terms of art in all different kinds of areas of law. And one of the things that you'll find is you will begin to learn these when you're in class. So if you're in property class, you will eventually, if you haven't already talked about what is a bailment. And that is just the term of art for a person temporarily giving their property to another person, the bailee, who holds it for a certain purpose. So if you take your dog to doggy daycare, leave your car at the ballet, drop off dry cleaning, those are examples of bailments. And so if you're trying to do some kind of research in that area, you're going to need to know that that's the term of art that's used. And there's really no way that you could just figure that out, no matter how smart you are. There's no way you could just intuit, oh, I bet that's called a bailment, until you are more familiar with an area of law. And that's, again, why secondary sources are so important to start with to get you the best terms to do your searching. Okay, so I've talked on and on about a research plan and how it can be as formal or informal as you like. This page has a bunch of different kinds of options for like pre-done checklist type of research planning guides. One is more like a template. This one's more like a worksheet. One of the most popular types is a flow chart. So it's just basically putting in one place all that I've talked about with you so far. Like you would start with, what am I trying to answer? What keywords do I know? You're assessing, do I have any knowledge in this area of law? And then you get into, do I know what the jurisdiction is? Do I need to look in secondary sources? Once you do, you have to make sure it's still a good law. And it just walks you through the steps of the legal research process. And you may find a hybrid works for you. Like you might do some checklists and also use this flow chart. Whatever works for you is great. You may have to try a couple to see what you prefer. So I have put together a little scenario for us to walk through that's going to use the legal research guided template type of template that we were talking about. Again, whatever works best for you is going to be the best type of plan. So let's just say we have gotten an assignment from our partner that your clients are 3 up-and-coming musical recording artists collectively known as the Lazy Kings. And that group has a large social media following after their hit song Oil Rigger, which is set to the tune of Conway West's hit song Gold's Digger. And it went viral. But now your clients, the Lazy Kings, have come to you worried that they're going to be sued for copyright infringement. And they've reached out to your senior partner to look into that issue for them. So what facts would you what facts do you know to start with that your partner would relay, the senior partner would relay? So the song was produced in their cousin's garage in California using free software. On the song, they basically make fun of Kanye West and the idea of working on an oil rig. And they said that idea came to them because they had a friend who moved to the Gulf of Mexico and actually started a job on an oil rig. The bad news is Kanye heard about it. And so the Lazy Kings were played on a main radio station in LA. And so on Twitter, he says, "I'm coming for you guys who made Oil Rigger. I'm the true artist and lyrical genius." And so now they're worried they could be sued for copyright infringement because their song is just Gold Digger, but with different lyrics. The best thing you can do whenever you get presented with the information you're going to start from is read that scenario a couple of times. You're going to try to figure out which facts are legally relevant. There's often going to be facts you'll find out were not that relevant. It can be intimidating talking to a partner, that's for sure, but it's always better to clarify any questions you have before you waste time doing the wrong thing and then eventually still have to come back to them and ask some questions. So I do encourage you to ask any clarifying questions that you need to as you're starting and as you go through the process, because again, as you research more, you will learn more and you may find that there's new facts that you need that you weren't originally given that are going to be legally important. Okay, so what does this template I was talking about look like? So this is the template that we're going to work through. It starts with what is the jurisdiction, what's the issue, what are some search words, what are these secondary sources that can help me. Then you get into the second kind of area. Okay, am I finding primary law? What is my mandatory precedent, my home jurisdiction? What are persuasive precedent available that I might have to use if there's nothing mandatory in my jurisdiction? The last part is make sure that you do that updating, shepherdizing on Lexis or Westlaw to make sure it's still good law. So it's just a blank template that you can print out and then work through whatever research problem that you're going through. So what jurisdiction would this problem be? Okay, I mean, it seems like California because everything mentioned here takes place in California. Like they played it in California, they made it in California. So at this time, I would say, it seems like California is our home jurisdiction. What issues are we talking about? So what we have background in knowing, not having taken copyright law or anything like that, is the copyright of song parody different than copyright for a song that is not any kind of parody? It's just a fully reused version of their song. What happened? They played it on the radio and it's also available online. It may or may not matter. What kind of remedies could your clients get? Well, it seems like they could get fines, maybe. Maybe they could be enjoined from using that song. Who knows? Who are the people involved? The band, Kanye West, we definitely know so far are involved. And it definitely seems like California is going to be our home jurisdiction. So any persuasive precedent will come from outside of California. And again, I encourage you, start keeping that journal anytime you actually start researching, because it's going to be so helpful to keep you organized. All right, so the next kind of step, what words might we use as keywords that we know now? Copy, parody, song, tune, beat, fair use, melody. Any of those kind of words could show up in the court opinion that might be relevant to us. And then on this side, you kind of keep a list of things you don't know if you don't know if they're going to be helpful yet. So like, does it matter that they publish it online versus played it on the radio? Does it matter that they use free software to create it? Who really owns the song? Like Kanye has contacted you, but does he really own the copyright? Does his label? Are there other co-authors or creators who also might want to sue you? And is it an exact copy of the song, or did they change it beyond just putting in the parody words? So those could become relevant as you're going forward, and you're just spending your time thinking strategically. What facts do I need to figure out, and how legally significant are they? So what do we know about this area? You haven't taken copyright law, but you know that there's this concept of fair use. just in general with copyright infringement, because like educational institutions have a fair use exception to the copyright. So do parody songs have that same kind of exception? You know, parody songs, you've heard songs by Weird Al Yankovic, and you know that there are federal copyright laws, but are there state copyright laws as well? That's something you need to be looking into as you're going forward. So this is what you do know and a little bit of what you don't know. I would highly recommend you would start in secondary sources to get background and context and to help you figure out what those keywords and terms of art are going to be. Again, there's a legal encyclopedia like AmJur. I would go and look in it and look up copyright. And that entry in that legal encyclopedia will give you a good broad overview of what is the area of copyright law. Are there statutes based? Is it a case-based system? What are the primary statutes or cases? And as I mentioned before, Lexis and Westlaw both have the American Jurisprudence Encyclopedia. So you next think, does California have its own state-specific encyclopedia? Is it on Lexis or Westlaw? Do state copyright laws preempt federal ones or vice versa? Continuing with your legal research or talking to a friendly reference librarian, you would find out that there is a state-specific legal encyclopedia that's called California Jurisprudence. So again, it's going to be even more tailor focused. If you looked up copyright in that legal encyclopedia, it's going to give you all of the information about copyright law in California. Once you've looked in those areas, again, legal research gold, see if there is an American Law Reports article on that specific topic that you're looking for. And it will point you to background, detailed explanations, and cite you to cases or statutes as necessary. And again, the ALR is available on Lexis and Westlaw. Step 3 would be to incorporate a treatise on copyright law to help you get even more detail and information. And you hope that there would be like a whole chapter that's just copyright. There's a chapter that's just all about parody kind of songs. And so you would have to figure out what treatises are available on copyright and do Lexis or Westlaw have those. Over on this side, I went into specific detail of how I would actually work through all of these 3 steps. I don't really have time to get into following all of the steps, but the general overview is you go to the American Jurisprudence. I highly recommend you look in the index and see if you can find a subtopic that's going to be exactly what you're looking for. And what do you know? Under the copyright entry in the AmJur, there is a whole section on parody. So I would highly suggest that you read the section that's called Purpose and Character of Use, Parody, Satire, and Burlesque. And then there's going to be tons of footnotes that cite to actual cases that are going to talk about parody songs in California. Near the top of that entry in the AmJur, there's even helpfully a listing of related ALR articles. So just by going to the legal encyclopedia, you're getting background, a good overview. You've already narrowed down to everything we'll be talking about a parody. And it's also telling you suggested ALR articles that are going to be helpful. And the article that they're talking about is 68 pages long with tons of detail and citations to statutes. So again, as I said, if there's a American Law Reports article on your topic, it saves you tons and tons of time. And we won't have much time to get into it now, but I have put together a whole other guide that goes by subject. So yes, there's all kinds of different treatises on copyright. Some are on Lexis, and like this one's 26 volumes. Some are on Westlaw, and that's only 7 volumes. So the bigger it is, the more detail you would assume that it would have in it. So we've assessed ourselves, we've looked at some secondary sources. Now we're moving into those primary source kind of phases. What do you know? The title of that ALR article is Parody is Copyright Infringement or Fair Use under Federal Copyright Act 17 USCA Section 101. it can't be much more clear that that particular statute is going to be highly relevant to whatever you're researching. The text of it will give, what the law actually is on copyright in that area in terms of copyright fair use or whether it's infringement. Specifically, that article mentions section 101 and section 107. And you'll see if you read through that whole ALR article, it never mentions any kind of CFR or Code of Federal Regulations, and that would be like administrative regulations. So it doesn't appear that that's going to be relevant as we're going forward. So the other thing the ALR article will give you at the top, you can break it down and it will have a table of contents kind of outlined for the article itself because they're always really long. And at the top, it's always going to say table of cases. And then you could say, I need to know every Supreme Court case that's ever talked about that because Supreme Court binds everybody on federal issues. So the Supreme Court binds all the lower courts on matters of federal law. So we are in California and the Ninth Circuit Court of Appeals is the appellate court, and the federal district courts in many different states, which includes California. So our precedent will come from the US Supreme Court if there's any, and then we have to be sure that we find any Ninth Circuit Court of Appeals that will be relevant. So as you're looking, that ALR article will tell you, click Supreme Court, there's a Supreme Court case. Click Ninth Circuit, here are all the Ninth Circuit cases that talk about a song parody. Right there, ready for you to go. You didn't even have to jump into Lexis or Westlaw and do a case search. You're already getting curated information on what's available. So as you get more into the ALR article, we found the section that was parody, but we specifically care about at this point songs that are parodies. And so there's also a section in the ALR that will show you the cases that are relevant. And again, it's pointing us to some that we've already seen mentioned above. As you're reading through, you may find that there's lots of case citations, but to places that are outside your home jurisdiction. So it looks like there's a lot of New York cases that are also dealing with this copyright parody song issue. So keep in mind, those would only be persuasive precedent, but it can happen that that's all that you will have available to you. So just keep in mind in your back pocket, I need to find all this California information first, but I may have to look into these New York cases if I don't find anything in our home jurisdiction. Okay, so now you've secondary sourced, you've primary source looked, you're ready to start that part 4, the reassessing kind of thing, and use what you've learned so far and look back and see what you would change about how you're going to do your research plan. So one of the factors that it talks about in that ALR article is that one factor courts consider is the potential effects of market value when it's looking into whether something is copyright infringement or if it's a fair use. So if none of those cases are from the Ninth Circuit, again, you would need to look outside the Ninth Circuit and possibly cite those as persuasive precedent. So then you have to ask yourself, has the band made any money from this song? Would they be willing to give any money they made like to a charity to kind of diffuse the situation? And again, that's where it can come in that you would then need to go back to your partner and say, there's new information I found. It's legally relevant to know how much money they've made off of it. Would they be willing to give it to a charity? And that's when it's really important that you go and speak with your partner again after you've done more of this research and have a lot more background knowledge in what's going to be legally relevant for your research. Another thing to keep in mind is we're talking about parody songs, but there may not be that many cases about parody songs. So you may have to look further and analogize things like there's parody movies, there's parody books. So they might also be important precedent in California that you can also use in your argument. Finally, we're at that last step, identify and update. So as you've gone along, I'm hoping that you kept a research journal type information of what secondary source you searched, what keyword terms did you look up, what pieces you found that were important using that, any other terms of art that came up that you wanted to further research. And then that last step is the shepherdizing or key citing to make sure that that case that you want to cite to the court is still good law. And again, just because it's red doesn't mean ignore that. You have to look and determine if the point of law you're researching is something that has been overturned or treated negatively. Okay, research journals. Again, I've spoken about it several times. It doesn't have to be anything super formal. I have a blank template form here you can use. It's just, what have you searched, where, what did you find, when? And there's lots of different reasons to keep a research journal. There's many reasons not to, like it just takes a longer time and it seems like you are wasting your time potentially, but I assure you in the long run, it's going to be helpful for you, not only to have a written record of what you have looked at, but if you are going to speak with a partner or a professor or a librarian, one of the first things they're going to ask you is, what have you searched and what terms did you use? So if you can then produce this document that goes into great detail about that, it's just going to help them help you even more efficiently. A similar idea goes with, if you spend all this time researching and you are just finding there's nothing, I cannot find an answer to what they're trying to say. You know, you don't want to go to the partner and say, I don't know, I can't find it. But one way to soften that is to be able to say, I can't find this, but here is everything I've looked at. And here are all the sources I've tried. And here are the keywords I've tried. And they will be able to pretty quickly determine, is there something major you've missed? Is there some keywords you still hadn't figured out? And if you don't have any supporting information of everything you tried, you know, there's just even less proof that you actually did look. And another reason is just because you don't research in a fluid line. You may spend like an hour on research one night, and then 2 days later you come back. You don't want to have to restart and forget where you left off. All right. So using cases in legal research, as we talked about, that's what you're actually going to cite to the court. So it's incredibly important. But there are important issues to look at when you're going to be citing cases in your memos or briefs. And that again comes back to precedent. So I highly recommend you check out my research guide on that. And a related issue is that case citations that you see are important to decode, because if you don't know what level or your court is, like if you can't tell that this particular citation to the F sup MDPA 1972, if you don't know what that means, you don't know if that's part of your home jurisdiction, is that a relevant court to you? So you will come to learn over time, and I encourage you to check out this guide. You will learn things like F sup, that's the federal level trial court case. And so it was heard in the Middle District of Pennsylvania. And just by looking at citation, you'll know all those kind of things. Excuse me. All right, so common issues. Also, just a recap of what we've talked about. Research is a skill and it's not meant to be easy. Thankfully, it's not. That's what they need you for. So you will get better at it over time. And it's going to be kind of a herky-jerky, kind of non-linear experience as you're going forward, as you find like you found something and you think that'll be great, but then you read the next thing and you find, oh, that I have to reassess everything I thought I know. And so my biggest recommendations are make a research plan and keep some kind of journal or log as the best ways to speed up the process of becoming better at research. Some of the common issues that people have, if you don't really understand the problem, you haven't asked enough questions to your assigning partner, you don't want to waste time and research the wrong thing. So make sure you really understand what they're asking you to do. Sometimes people still haven't found those terms of art. So if you're not finding much, try a different type of secondary source. Um, yes, and always you can contact a friendly law librarian. We're more than happy to speak with you about your research. Then the last common issue will almost always be where do I stop? Make sure that you've always done your shepherdizing or key citing to fully update that. Once you've gone through a research plan that you put together, you can feel pretty confident that you have looked in all the places that are important to find. And again, the biggest clue is that you will start to see everything that you read refers to cases or statutes that you've already found. And that's the best indication that it's time to stop your research and you found all that there is. I also have for you all additional resources if you want to learn more about the process of legal research. We've got some books on making research plans. There's also study aids that are specific to legal research, and those are available to you all. And again, there are some recommended Cali lessons if you would like to use those. If you don't know what the code is, please contact me or any other reference librarian, and we'll happily tell you what that is. So that's a whirlwind, and I just really encourage you to take your time, begin your research, come up with some kind of plan, whether it's a more formal situation or a little less formal, that's really up to you. But if you go through your research and you address all 7 parts of this, you are going to be pretty confident that you have done a really good amount of research. So again, don't hesitate to talk to us. If you want to contact me, my email is M as in Megan, GARTON @tulane.edu. And I am happy to schedule an appointment to speak with you. Most of this is going to be important in your next semester because this semester you're doing a closed memo. And closed means they're basically going to give you all of the research that you'll need. But the open in the next semester means you will be doing all of this from scratch on your own. And so just keep in mind that nice librarian, she has this research guide for me. I can talk to her. There's these things called secondary sources that could help me. And I'll be more than happy to speak with you whenever you are ready. So thank you for letting me speak today and have a good rest of your day.